and when the body politic gets sick, medicine must be administered. Dr. B.R. Ambedkar. I unquote. On behalf of Justice Bashir Ahmed Syed College for Women and the Department of Corporate Secretariship and Information Systems Management, I deem it a great honor to extend a very warm welcome to all of you for the webinar entitled Recent Trends in Company Law in Commemoration of National Law Day. We also appreciate each and everyone joined us today and hope the webinar lined up to be fruitful and engaging. To begin the webinar with a spiritual note, may I invite Dr. Shaheen, Assistant Professor, Department of Corporate Secretariship and Information Systems Management, to invoke the Almighty.
Assalamu alaikum wa rahmatullahi wa barakatuhu. Meaning, peace and blessings of Almighty upon all of us. Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. Ar-Rahmanir-Rahim. Maliki Yawmiddin. Iyyaka na'budu wa iyyaka nasta'in. Ihdinas siratal mustaqim. Siratal lazina an'amta alayhim ghairil maghdubi alayhim waladdallin. Ameen. Surah Al-Fatiha. Translation, the opening, the chapter 1 of the Holy Quran. In the name of Allah, the most beneficent, the most merciful. All praise is due to Allah, the Lord of the world, the beneficent, the merciful, Master of the day of requital. Thee alone do we worship, and Thee alone do we beseech for help. Guide us on the right path, the path of those upon whom Thou hast bestowed Your favors, not of those upon whom Thy wrath is brought down, nor of those who have gone astray. Amen.
Thank you, Shaheen. I now invite Dr. Kalpana, Assistant Professor, Department of Corporate Secretariship and Information Systems Management, to render the welcome address.
Thank you, Siri. Good day, all and all gathered here virtually for the webinar and recent trends in company law organized by the Department of Corporate Secretariship and Information Systems Management. On behalf of the management, principal, vice principal, head of the department, and faculty members, it's my honor and privilege to welcome you to the webinar on recent trends in company law in connection with Commemoration of National Law Day organized by the Department of Corporate Secretariship and Information Systems Management, Justice Bashir Ahmed Syed College for the next demo. It's my great pleasure to welcome our eminent resource person, CS Dr. B.R. He is a fellow member in company secretaries in India. He will also obtain doctorate in corporate governance and boardroom management in India from the University of Madras. He worked for Converse Group of Companies nearly 25 years in different capacities in secretarial and legal departments. He commenced his practice from the year 2000. He is an advisory to leading companies and banks on corporate law matters. His areas of specialization are in corporate restructuring, due diligence, secretarial audit, and all legal and company law issues. He was a faculty member of the Institute of Company Secretaries and the Institute of Chartered Accountants of India for more than 3 decades. He is also a visiting faculty member in Madras University and other leading colleges. He is one of the professional specialist editor of Guide to the Companies Act 2030, and he also authored the book titled Company Law Made Simple. He has presented many papers and articles in various seminars organized by the Chamber of Commerce, associations, and professional bodies. He is a recipient of Best Speaker Award and Company Law from the Chartered Accountants Study Circle and the Vocational Excellence Award in the year 2011-12 from Rotary Club of Madras. In spite of your busy schedule, thank you for accepting to share your knowledge with all of us here. We are all excited to have you here, and this will be an opportunity for us to learn from a learned expert like you, sir. Once again, welcome you, sir. I also take this opportunity to welcome all the participants for this webinar. I wish all of you have a fruitful learning to work forward to share this knowledge for the betterment of our student community. Thank you, and have a great day.
Thank you, Ma. Moving right along, I now request our guest speaker, an eminent personality, Mr. Ravi, to take over the session.
இனிய காலை வணக்கங்கள். இந்த கருத்தரங்கிற்கு வந்திருக்கும் அத்துணை பேராசிரியர்களுக்கும் நல்ல உள்ளங்களுக்கும் அடியனின் வணக்கங்கள். நான் எந்த நிகழ்ச்சியை தொடங்கும் போதும் முதலில் சிறு தமிழில் பேசிவிட்டுத்தான் கமர்ஷியல் லாங்குவேஜுக்கு வருவேன். காரணம், தாயையும் தாய்மொழியையும் தாய் மண்ணையும் மதிக்க வேண்டும் என்பது எனது தாழ்ந்த அபிப்பிராயம். With this, let me get on to the official language so that we can discuss on the topic recent trends in company law, a topic designed to celebrate the National Law Day today. Before proceeding to present my changes that has taken place in the company law, I would like to give you a brief introduction so that will facilitate to get a better appreciation and understanding of the changes I am going to discuss with you. Before that, am I audible to all of you?
Yes, sir.
Thank you. Originally, we had the Companies Act 1956 for more than 5 decades, and the government thought it fit that it is high time we should try to get into the details in the Companies Act 1956 and try to link it with the international development and bring out a new piece of legislation with the prime objective, ease of compliance, ease of living, and similar motto. This has given birth to the new legislation after a long deliberation of more than a decade, the Companies Act 2013. While drafting the Companies Act 2013 and bringing them into existence from 1/4/2014, barring few provisions started little earlier, the law was made applicable to all companies at par, whether you are a public company or a private company or a company intended for charitable purpose or one-man company, etc. Then, as time passes, the lawmakers have realized that all the provisions cannot be made applicable to all categories of companies or classes of companies at par. It is necessary to provide some relaxations, concessions, and exemptions. So, on 5th June 2015, to be more precise, they came out with notifications relaxing and exempting certain provisions of the Companies Act with reference to categories of companies like government company, private company, Section 8 company, which we call them as, earlier it was Section 25 companies, and the like. So, from 2015, we could see there are drastic changes, and year after year, because it is a new law based on the experience, they have started amending the provisions, and you will be seeing in the 2013 Act a unique quality, namely many of the provisions will have the word prescribed. The reason being, whenever a change has to be brought into a legislation, it has to go through a process. A concept paper will be conceived. That concept paper will be placed before the public at large for their consultation and suggestions. Based on that, a bill will be drafted. The bill will be placed before Lok Sabha and Rajya Sabha. Then once it is cleared by them, then it will go to the President for its assent. Then it will be notified in the Gazette. And for different provisions, different dates can also be prescribed, the date from which that particular provision or changes will come into force. This has created a huge gap between the date on which you have conceived the idea and the date on which actually it has been implemented. This considerable delay has to be avoided because it is fundamental. Anything that is delayed is denied. Therefore, the legislators thought it fit when they brought in this 2013 Act to use the word prescribed in most of the places so that they can try to regulate or bring in changes by way of rules amendments, which need not go through this process. The central government has its power to frame rules and to amend, notify from time to time different provisions. This background has to be kept in mind, and right from 2013 till today, probably it will be difficult to capsulate all of them within the span of the 80 to 90 minutes that have been allotted to me. Therefore, I have decided, because the title is Reason Trend, the definition for reason no one can give. Therefore, I have decided for the last 2 years, say from 1st January 2021 till yesterday evening, what are all the changes which are very essential that one needs to understand. I have put it in the form of a slide presentation. So as I go through the slide, I will explain you in a short form what those changes are. That will help you to understand and probably pass it on to the students also while you are giving the lectures. So the amendments I am going to cover, because there was recent amendments to Companies Act 2013. The coverage is from 1st January 2021 to 25th November 2022. That is still yesterday. The first one is with reference to listed company. Generally, when we understand the term listed company, we mean only those companies whose equity shares are listed in the stock exchange. But if you see the definition that which is given under section 2 subsection 52, it says listed company means a company which has any of its securities listed on any recognized stock exchange. The term security is widely defined. The definition section itself will tell you the word security encompasses or embraces within itself shares, debentures, bonds, units, and so on. Therefore, if any one of them is listed, even though your equity share is not listed, you are qualified to be called as a listed company. Then accordingly, there were stricter regulations for a listed company. But that was not the intention of the lawmakers. Therefore, they brought in a provision with effect from 22/1/2021 by way of a proviso, saying that such class of securities as may be prescribed in consultation with SEBI, they will not come within the definition of listed company. What are they? The notification says, for the purpose of 2 subsection 52, the following classes of companies shall not be considered as listed companies. If you are a public company, but your equity shares are not listed, but non-convertible debt securities are issued on private placement basis, or non-convertible redeemable preference shares are issued on private placement basis, or you are a private company and you have listed your non-convertible debt securities on private placement basis, then you will not be called as a listed company within the meaning of this act. Similarly, public companies which have not listed their equity shares on a recognized stock exchange, but whose shares are listed on a stock exchange in a jurisdiction outside the territories of India, not the company. This assumes significance because this particular definition, because the listed companies are required to have certain compliances even under the Companies Act, leave alone listing obligation and disclosure requirement, which is affectionately referred to as LODR. For example, if you take audit committee, or if you take nomination and remuneration committee, which are all the mandatory committees given under section 177 and 178 of the Act, you will be seeing that every listed company should have. Will I get covered there? So this definition will help you to decipher that information. Are you a listed company within the meaning of this Act, requiring you to have audit committee or nomination remuneration committee, etc. Similarly, with reference to independent directors. So wherever the term listed company is used, your attention should immediately go back to section 2, subsection 52, with the clarification that has been brought in by way of the proviso and notified on with effect from 1/4/2021. That will help you to define the term listed company and its applicability. Then comes a unique category called a small company. Many of the startups are small company today. In 1956 Act, we have heard of only 4 categories of companies or 5 categories of companies: public, private, government company, Section 25 company, which now called as Section 8 company, and a new avatar came in called as producer company subsequently. But in 2013 Act, we have some unique category based on international experience, namely one-person company, small company, and dormant company. Now, why we have the concept small company? It is not fair to treat all companies alike with reference to the compliance provisions under the Act. There are small companies which are slowly trying to develop themselves. So they have fixed a parameter for that or benchmark for them based on paid up share capital and turnover. And if you fall under that particular category and you do not exceed that amount, you will be blessed with the title small company, provided you are not a holding company or a subsidiary company. You are not a Section 8 company, or you are not a company governed by any special act. So even if you meet the parameters, if you are a holding company or a subsidiary company or a Section 8 company or governed by any special act, you will not be called as a small company. So you have to keep this in corner of your mind. So therefore, if you are a small company not coming into the proviso, but you have a paid up capital is 4 crores and it's a cumulative condition, turnover of 40 crores. Now this 4 crores and 40 crores is inserted recently, somewhere some 15th of September 2022 or so. Recently it has been inserted. So a lot of companies got benefited because of that. Then you can ask me, sir, what is the advantage of being qualified as a small company? Many of the provisions, to cite a few, for example, number of board meetings that you have to have, the time gap between 2 board meetings, or the concept of rotation of company auditors, which is mandatory, otherwise will not apply. And there are certain provisions in Rule 8, categories of information required to be given in the board's report. If you are a small company, you are exempted. And similarly, with reference to the annual return, who will be the signatory? And cash flow statement need not be attached if you are a small company. And lesser penalties are also prescribed for small companies. Like that, the law, as it progresses, has given a lot of exemptions if you fall under the category of a small company. So this definition assumes significance only because of the fact it is a new amendment. Earlier it was 2 crores and 20 crores. Now it has increased to 4 crores and 40 crores. So this is probably keeping in mind the startups that are coming up. Since startups are flourishing now and that is becoming order of the day, they thought it is necessary to have the term small companies parameter is also redefined. Then we have this one-person company, and this one-person company originally when it was brought in under the 2013 Act, only resident in India can form a one-person company. That means a foreign national cannot form a one-person company in India. But slowly, as time progresses and seeing the various foreign collaboration, foreign investment requirements and other things, the government thought it fit. We should facilitate even a foreign citizen to promote a one-person company in India. Therefore, the word or otherwise has been added now. And the term, when you are called as a resident in India, there are 120 days immediately preceding the preceding financial year. Earlier it was 182 days, now it has been brought as 120 days. This is more for information. That means not only an Indian person but also a foreign citizen can promote a one-person company in India. What is one-person company? It is nothing but a sole proprietary enjoying the body corporate status under the Companies Act. Then we have an amendment on 24th December 2022. I am going chapter wise so that easy for you to follow. I am not going by the date on which the notifications have come into force. Extension of reservation of name in certain cases. Today we have two options at the time of incorporation. You can have the name made available for you and reserve the name, and within a prescribed time submit the documents that are necessary for incorporating a company. Option 2, at the time of making an application for incorporation, you can also feed in the information with reference to the name availability. See, if the name made is available, that is requested for is available and the documents are in order, simultaneously it will be done. Now, for various reasons, there could be a delay, the time limit within which after the name is made available for you or reserved for you, you will not be in a position to complete the documentation. Then the law gives you extension of time. But extension is not coming free. There is a fee that has to be paid depending upon the number of days that you are seeking for extension. So that has been brought in on 24th December 2022 and it has come into force from 26/1/2020. Though it is 26 coming to force from 26, but it's a retrospective effect they have given. Then this is a unique feature with reference to the name availability. What is this unique feature? Earlier, after the formation of the company, companies used to run from pillar to post to get the various registration, like the GST registration, employees provident fund, employee state insurance, professional tax registration, even for opening the bank account and getting registered in the shop and establishment, etc. Now, it has been facilitated at the time of incorporation itself by filing the accompanied e-form called as Agile Pro, that is INC 35 or so earlier, containing an application for registration of the following numbers. When you key, along with that incorporation document, this particular document also, once the company is incorporated, probably in general, within 24 hours, all these names are also being allotted to you. So from birth, you have all the numbers. It is not mandatory, you must ask for it, but this is a facility that is being made available in the Companies Act by way of an amendment. Then of course, this is nothing but whenever you are forming a Niji company, you require a separate approval for it. And that approval, if you say that we will not come into the business unless we get it cleared that we are a Niji company, that undertaking should be annexed along with the application. And this was a provision, in fact, it was a salutary provision. We do not know why the legislators have removed this. The reason being, there are sometimes we make application, but after making application, we will wait for the government approval. And most of the times are, if our luck is not in our favor, the papers will get delayed by months and years. Therefore, the law provided as an inbuilt mechanism, which was there under the old legislation called as MRTP Act, Monopolies and Restrictive Trade Act of 1969, an inbuilt provision was there. When the government approval is not forthcoming within the prescribed time, it is a deemed approval. That means government has no objection. The system itself will generate the approval later. It was also there under the 2013 Act, and for reasons best known, that has been removed now. And this is a procedural formality, so nothing to be discussed on this. This is rectification. Rectification is different from reservation and change of name. Reservation, at the time of formation, you would like to reserve the name with which you would like to have your company to be formed. Change of name is the system whereby you yourself voluntarily would like to have your name changed for a variety of reasons. Because of change in promoters, change in the object, or even today the situation has gone to the extent because of numerology, astrology and other things. But rectification is different. inadvertently they have allowed a name with which you can form a company which resembles that of an existing company, then the first named formed company can make an application to the government asking the later formed company to change its name, and government has the power to direct them, provided the procedural formalities are followed. There is a lot of application is required to be made, hearing will be given. After giving an opportunity of being heard, if the government is of the opinion, yes, it has inadvertently allowed, then they will direct the later formed company to change the name. But changing the name, they should not take their own sweet time. So the law has provided a time limit within which the rectification should be made. If the rectification is not made within the time prescribed by the government, then a new provision has been added by Rule 33A, capital A, whereby they have stated government itself will allot a name and issue a fresh certificate of incorporation. And so it becomes automatic, and there will be an endorsement on the certificate of incorporation. This is a company which defaults in complying with the order of the regional director. So that stigma will be attached. So normally no companies will go to that extent, but there is a provision that has been brought in by way of 33 capital A. At the time of formation, I wanted to start as a sole proprietor, but after some time, my business grows. And when my business grows, no business will run without money. So I have to approach financial institutions, banks, etc. So they will be willing to give the credit facilities only based on your credit worthiness. If you are a one-person company, it is only you and you alone. And therefore, the chances of you getting the required funds becomes little difficult. Therefore, if you get a corporate status like a private company or a public company, then you stand to a better, a privileged situation to get the funds facility. Therefore, the law has provided now, by way of an amendment, a one-person company can convert itself into a public company or a private company subject to the compliance of the various procedural requirements which are given in the rules, which I am not getting into the details because it is only the information that I am required to pass it on. But one thing is, you cannot get registered as a Section 8 company. That is not permitted. But what is required is you can convert yourself as a public company or a private company and not as a Section 8 company. If you fulfill the requirements that is given in the rules meant for that and filing the required form like INC 6 or so, then probably you will be able to get yourself converted either as a private company or public company. In fact, you can go stepwise also. From OPC, you can become private first, see what all the benefits that you enjoy. After enjoying all the benefits, if you feel that you are growing still further, you want to go to public at large, then you convert yourself into public company. The reason being, when OPC to public, if I get converted at the first stage itself, your compliance requirement will become more. Because private companies enjoy a lot of exemptions, public company do not. That is the reason. And this is again a private. Can I do the reverse? I am a private company. I thought no longer private. For example, it may so happen in a situation where husband and wife are the directors, shareholders, etc. Unfortunately, one of them is not in existence. The other may continue with another partner, or they can convert them back as a OPC. That is also possible by passing a special resolution. No threshold limits and all is there. Prior to the amendment to the rule, there was a threshold limit. Now a private company can get converted itself into a one-person company by passing a special resolution in the general meeting. Now there are certain problems we are facing. All of you would have seen in the news item. And there are some fake companies are being formed, and there are companies which are linked to country like China and others. So now they have stated, either at the time of incorporation or when you are making a private placement, there should be declaration by the person saying that shall be made to a body corporate, incorporated in or a national of a country which shares a land border with India. unless such body, corporate organization got the clearance from the appropriate authority. Now, for the purpose of 62 talks about rights issue, and it talks about ESOP and other things. Under rights issue, there is a provision. When you make an offer, it should be kept open for a period of not less than. The legislators thought the period is too long. Therefore, now they say it is sufficient, can be made, acceptance shall be made not less than 7 days from the date of the offer. So only the 7 days time has been prescribed. Only thing is the time, if I am right, earlier it was 15 days or so. Now it has been brought down to 7 days or 14 days to 7 days. Now this is only an exemption with reference to the creation of a charge. When it is done by a bank with reference to the Reserve Bank of India, the formality need not be complied with. Now there was a provision with reference to declaration of beneficial interest, that is who is holding the ultimate control. 89 and 90 significant beneficial interest, etc. are there. So the government has brought in by way of a subsection called as subsection 11, whereby they say that certain classes of companies are granted exemption from the operation of subsection 10. Well, this is a very interesting situation with reference to the annual return. All of us are aware we have two categories of returns. One we call them as periodical returns, the other we call them as a casual return. A periodical return is one that is required to be filed whether an event has taken place or not. Whereas a casual return is one, it will be filed only when the event has taken place. For example, the financial statement and the annual return has to be filed whether or not the annual general meeting has taken place, whether it is adopted or not, if adopted as adopted, if not adopted with the reasons, and if it is adjourned, again a provisional, subsequently the final. Similarly, the annual return is required to be filed within a prescribed time of 60 days from the date of AGM. So the AGM is the starting point. Suppose the company does not hold the AGM, what will happen? The date on which AGM ought to have taken place. So these are the two returns which we call them as periodical, because the event being the annual general meeting, whether it has taken place or not, these two returns should be in the public domain. Government has brought in lot of changes in that. For example, class C has been omitted, which is nothing but particulars of indebtedness. Similarly, with reference to shares held, you need not give the full details about the foreign institutional investors. Earlier, you will be giving almost the entire horoscope of the foreign institutional investor. Now we need not give that. Then the government has coined what is called as abridged annual return. If you are a one-person company or a small company, let us not trouble you with all these details. So they have brought in a form called as abridged annual return, and normal annual return is titled as MGT 7, and this abridged is called as MGT 7 capital A. This is what I have narrated again in this slide. For the financial year 2021 onwards, MGT 7A will apply. Now there is a facility that is being given to the members, to the debenture holders, to an outsider to inspect the documents of the company. There are registers called as statutory registers. The law has very clearly mandated who is eligible to inspect what, when they are eligible to inspect, what they are eligible to inspect, and whether they can take copies or extracts from that particular register, whether with payment of fee or without payment of fee. Now they wanted to make clear certain information that are there in the registers which are privy or close to that particular individual concern should not be made available for inspection, or extracts or copies can be given. Like for example, the registered address, email ID, unique identification number, PAN number need not be disclosed for the person who is coming for inspection. Now e-voting has come to stay. Now e-voting has given a lot of facility because it helps the shareholders wherever they are to exercise their right. So an exhaustive provision with reference to the methodology to be followed by a company when they give this e-voting procedure has been detailed in rule number 20 of the company's management and administration rules 2014. Now there are various terms that are being defined therein, which was not originally defined when they brought in this concept. Now they thought it fit. It is better we define them so that there will be clarity with reference to what do you mean by secured system, what do you mean by remote e-voting, what do you mean by cyber security, what do you mean by cutoff date, etc. A notification was issued with effect from 5th March 2021. All those provisions will apply. This is more for our guidance, and it is not going to be in any way changes the rules relating to e-voting process. And there is a section called as 117, which requires certain documents which are required to be registered, documents, agreements required to be filed with the regulator. And the law has now, by way of 117.3 subclass G, the proviso, if you are a banking company or an NBFC, as the case may be, or a housing finance company, etc., and those resolutions with reference to granting of loans or giving guarantee or providing security in respect of the loans in the ordinary course of business, provided nothing contained in this clause shall apply. That means they need not intimate in that prescribed form. The prescribed form is MGT 14. So they are given an exemption for those categories of companies. Now comes with reference to 124 that deals with the penalty provision. I will explain about this before I conclude my session, because there are 2 to 3 points which I thought I would like to discuss with you in a slightly elaborate manner. Probably before my closure of my session, I will tell that. This is more of academic interest with reference to Investor Education Protection Fund Authority Amendment Rules 2021. All of you are aware of the fact dividends are being declared. You have a concept called as interim dividend, final dividend and all. And the dividend when declared is required to be transferred to a special account, a dividend account within 5 days, and from there it should be declared with paid to the shareholders within 30 days from the date of declaration. And if it is not done so at the expiry of the 30th day, it will be transferred to the unpaid dividend account within again 7 days or so. Some time limit has been prescribed. And from there again it remains unpaid for a period of 7 years. Then it is transferred to the Investor Education Protection Fund. And now the law has mandated even the underlying shares will be transferred to the Education Protection Fund, and all the benefits, etc., that is accruing to that will also get accrued there. If the person concerned is finally able to trace it and bring it by giving a proper proof, he can get back it from the authority. But no, this particular provision was made stricter because no wrong person tried to exercise the rights or enjoy the benefits out of that. That is the reason why it has been brought in. This is also with reference to the same on Investor Education Protection Fund. Now, as far as the accounting is concerned, a huge amount of tightening of the various norms relating to accounts, books of the companies, disclosure, everything has been there. And almost every month you get some notification with reference to this. The reason being, or the experience gained by the various scams and various defraud committed by corporates and some businessmen, unscrupulous business fellows, we used to say, because all businessmen are not criminals. So keeping that in mind, they wanted to have a software inbuilt, which is mandatory with effect from 1st April 2023, that is the next financial year onwards, where you will have the accounting trail. That is, from where does it originate? So the software must be in a position so that it will be easy to track from where, whether it is a round tripping the funds or is it a genuine transaction. So this is a very salutary provision. It will put checks and balances so that let us hope that corporate frauds gets minimized because of this particular development. Then this is refers to the relaxation provided in reference to consolidation of financial statement. A proviso was added. In respect of consolidation of financial statement by a company having subsidiary or subsidiaries incorporate outside India only, for the financial commencing on or after 1st April 2015, how they have to consolidate or need not consolidate. And this is with reference to additional information you are required to provide. And this is because of the IBC, that is Insolvency and Bankruptcy Code, has gaining momentum. And the difference between the valuation done at the time of one-time settlement is also required to be disclosed. This is also adding on the matters that are required to be disclosed in the board's report. Then you have this famous statement called as corporate social responsibility. This is gaining momentum, and every day the emphasis is becoming more. People are fully aware of this. Corporates are fully aware of it, especially with reference to the change in the climate that is taking place, and with reference to the carbon emission. And keeping all these things in mind, the CSR is gaining momentum. And this is another point which I have reserved. Before I conclude, I will explain in brief the whole story so that you will get an understanding about it. What is the CSR? How is it important? Lot of changes have taken place, especially with effect from 22nd January 2021. And there are two concepts called as one-time project and ongoing project, and transfer and the utilization. The legislators are very strict with reference to the implementation of CSR, and LODR on its part with reference to the listed company. They also modified the business responsibility report as business responsibility and sustainability report, and therefore the sustainability is also possible only when CSR is in place. And this is also with reference to CSR. So when it comes to it, I will explain to you. Then comes the next one with reference to the reporting about the various CSR activities. There is the format CSR2, and for the purpose of 31st March 2023, you have to file it along with the form. After filing a form AOC4, AOC4 is the form number. That's it. Nothing. It is nothing but a form number to which the financial statements are being annexed. Depending upon whether you're an NBFC, whether it's required to come under XBRL or you are covered by NDAS, accordingly the form will differ. The CSR2 yet to come into format because it's only for 31st March 2023. For 2022, already the format is available. There are various matters that are required to be included in the auditor's report. You can see today, unlike the earlier carrot we used to call this with reference to the auditor's report, which are just a couple of pages. Now auditor's report and disclosures and disclaimers runs into almost 20 to 30 pages in any big company's financial statement. The reason is the responsibility on the shoulders of auditors have increased, and the law mandates that the auditor's duty to probe into the details and to disclose to the public at large, or I mean when I say public at large, first to the shareholder, then to other stakeholders, and about the performance of the company and the status of the company, so that they will take an informed decision whether to continue with the company or to invest more or to reduce their investment in the company. So one such change that has been brought in is with reference to the knowledge other than the research which has been disclosed, including foreign entities, whether any foreign entities have been funded for this purpose. So a lot of things. I think each one, if I have start explaining, it will take 10 to 15 minutes. Since considering the time frame, these are the changes that has been there. So please run through them and get itself fully acquainted with the information. Make it into one line or two lines to make the students to understand in a simple way. And with reference to the directors, and we have the category called as independent director today. The independent director plays a very significant role, and for them the law has stated different process. As you all aware, to become a director, unless otherwise I have that identification number, I am not an eligible bachelor to become a director. But to become an independent director, the law requires little more. There is a data bank in which you should have it registered, and you are required to pass an eligibility examination within a prescribed time. And then the independent director started raising their voice saying that, look, we are in the business for the last 15 years, 20 years, we are already a professional, I'm a chartered accountant, I'm an advocate, having 10 years, 20 years experience, or I was working in the Ministry of Corporate Affairs for the last 10 years, I am in the rank of secretary, joint secretary, and so on and so forth. So why do you require us to pass an online proficiency self-assessment test? So the government thought it fit, and they found that their crying is also have some meaning behind it. Therefore, they started relaxing and given exemption for certain categories of people who need not take that online proficiency test, but registration with the data bank and various other norms that are prescribed with reference to an independent director by way of a schedule. If I'm right, schedule 4 or so talks about the code for independent directors, that has to be adhered to. You can be a lifetime member by way of a data bank, or you can be for 5 years, or you can every 1 year you can renew. Choice is yours, but the law has provided various steps for that. This is what the same self-assessment test which I was making a mention. Once you become an independent director, for that matter, any director, you are required to update your knowledge. We call them as a capacity building. This capacity building is there in all the professional institutes, and periodically they used to conduct. In fact, various colleges in which I am in the board of studies, I used to advocate this point. Once in a year at least, all the faculties of the legal department or those who are taking law, whether BCom or corporate secretaryship, they should be brought together and a session should be drawn on the various laws that they teach. What are the updates that has taken place? Because the probability of they getting to know those updates on a daily basis, or the impact of the same, or the various judicial pronouncements that are there, the probability of they knowing them may not be 100% with everyone. But I know all the professors are up to date today. I have great respect for them because I also belong to the same fraternity. But all said and done, we used to have this capacity building program. And this capacity building program will help not only the faculties, but also down the line when they educate the students. Because I know still when I was having a discussion in a particular session in the Madras University, when I was talking that this particular provision has been abolished long ago, but it's still there in the syllabus, what they are mentioning. I said that concept has been deleted. Why you want to teach them? They said at the time when we introduced that particular, with them, that provision was there. I said it is not proper. I took up that matter up to the Vice Chancellor. So because when you go for an interview, our product, our student, when they go for an interview, when they ask this question, when they say this is the situation, then the person concerned, the recruiter, may not be impressed because he is not up to date on the subject. So it is our responsibility. We have a social responsibility also as a professors to ensure that the up-to-date point is being made known to the students, for which we should get ourselves have the capacity building in place. This is only my suggestion. Choice is yours. And this again, at the time of incorporation or appointment as a director, you should take a declaration, clearance from the Ministry of Corporate Affairs, especially if the person is coming from any country which is in the land border with India. This is a very salutary provision. In fact, we should appreciate the lawmakers for this, because under the company law, the board of directors meet and take decisions. There is a specific section under the Act which mandates that in certain provisions should be done only at a meeting of the board. And elsewhere also under the Companies Act, there are provisions where the law mandates the decision should be taken only at the meeting of the board. And wherever such a mandate is not there, then you can have the decisions taken through a resolution passed in circulation, which we affectionately call them a circular resolution. And there are provisions relating to that, how you have to send a circular resolution, when is it required to be passed, etc. Now, there are, with the way in which things are developing and the world is becoming a global village now, people are from different countries are becoming a member of your board. And time difference is there. For every board meeting, you can't expect them to fly down. But the law has restricted by way of a provision saying that certain provisions you can't discuss through video conferencing, you must meet and discuss. Then as things develops, they found, especially at the time of COVID situation, they found it that it is not practically possible because flights were almost, in many countries, flights were not there. And under those circumstances, approval of financial statements or board's report or prospectus or audit committee approving the financial statements will come to a standstill, and more so with reference to corporate restructuring. Therefore, the legislators thought it fit we should relax, and they have removed the rule itself. That means today, if you think it is feasible, have a board meeting and discuss. If you think it is not possible, that you would like to have the video conferencing, have the meeting through video conferencing and transact any item that you deem fit. So that particular restriction or the fettering the powers of the board which was there has been removed now. So you are in a better wicket now as directors. So hereinafter we can't say that the decision could not be taken because there is no board meeting, this director could not come because of this reason and all, because video conferencing and other audio visual means is possible today for every item relating to the company. This is with reference to the merger and amalgamation, where the law has permitted two or more startup companies can merge, or one or more startup company with one or more small company can also merge and amalgamate. Earlier it was not there. Now Rule 25(1)(a) got inserted, and you can do that. And this is also with reference to the sharing land border, that is cross-border mergers, you require a special approval for that. These are all removing the names and other things. This, I think, may not be of much interest to you all. Nidhi rules also has been brought in. Now, there are 2-3 things which I said before I conclude I wanted to deal with you. One, with reference to Schedule 3. Schedule 3 talks about the accounts format. Huge amount of disclosure has been contemplated by way of different amendments on different dates. So it will take a very long time for me to put them in the slide, and that's why I didn't do it. I earnestly request all the faculties, especially who are dealing with accounts, to look into the Schedule 3 and the various disclosure norms that are required to be made in the financial statement. Because they want the minute details, and please take it from me, everything is online today. So they are able to have a network system, not only with the Ministry of Corporate Affairs, but also with the finance, with reference to the income tax, with reference to GST, and all departments are being related. So by pressing a button, they will know the details, they will link it from all the departments. So a non-disclosure in one, a disclosure in another immediately can be tracked, and you can be questioned. Therefore, the disclosure should be correct, disclosure should be proper, and disclosure should be timely, and disclosure should be adequate. So all these points should be kept in mind. I once again appeal to all the faculties, please run through the Schedule 3, and whatever you think that it is necessary for the students to know by way of disclosures, keep them informed. For example, even the preference capital, if you see, normally the way we disclose preference capital in the capital breakup vis-a-vis today, where it is being shown, there is a difference. So you have to look into that. The next one is reference to Schedule 4, that is remuneration payable to companies that are in profits and no profits. That is with reference to the remuneration payable to directors. There is always what is called as a feel with reference to the independent directors. They are specialists, they have the extra expertise, and they are acting fearlessly, favorlessly in the boardroom, and therefore, but they are not being remunerated properly. There is another school of thought which says, unless you pay them adequately, you will not get the right person in the right place. Okay, so keeping that in mind, the government thought it is necessary to relax the restriction with reference to remuneration. Already a huge amount of relaxation has been provided. All the restrictions with reference to the percentage, like 1%, 3%, 5%, 10%, overall 11%, all becomes only numbers today, because with the shareholders' approval, you can pay whatever you want to the directors. There is no limit at all, including a case where the company has no profits or inadequate profits. But when you come to independent director, the law specifically provides he is not eligible for any remuneration except profit related commission, and he is eligible only for, not eligible for stock option, but reimbursement of expenses like or sitting fees with reference to the meetings that he attends. So that is not adequate, because even if you give him the topmost figure that is available under the Act, 1 lakh per meeting, even if he attends 10 meetings, he gets only 10 lakhs per annum. And whereas when he, as a consultant, when you work somewhere, he will get much more than that. Probably that 10 lakhs will be per month, will be his remuneration. So you don't get the right person. And therefore, what happens is many unscrupulous companies, they started doing what is called as a tick box exercise. Those who fulfill the criteria, appoint them as an independent director. That's it. Because under 149, if you see under, I don't know whether it's subsection 6 or 7, they're given a huge amount of conditions to be fulfilled to become a director, to make a director and independent director. When it becomes, you appoint your servant, you appoint your director, you appoint your driver, you appoint your cook, also as an independent director, because we fulfill all those conditions. But you fulfill the requirement of law, but the benefit with which, or the intent with which you brought in this independent director has been lost. Therefore, the government thought it fit, we should remunerate them properly. So they have relaxed the condition now. They have used the word you can pay remuneration to other director also, similar to that of the KMPs. And that word other director has been defined to mean a non-executive director or an independent director with effect from 18th March 2021. In short, independent director can also be remunerated monthly, can also be remunerated half-yearly, can be remunerated annually. It is your choice. You can do that. So you will get the right choice by having the right person, right type of remuneration that is being paid to the independent director. Now, before I conclude, two things which I want to share with you. One is with reference to CSR. CSR rules have been amended, and the amended version, kindly go through the amended rules because it runs into 3-4 pages. But you have to remember some 5-6 points only in that. That 5-6 points, if you try to elaborate to the students, that is more than sufficient at the student level. For example, what should be the quantum that a company should mandatorily dedicate to CSR? There is a percentage that has been provided under the Act. And there should be a specialized body which should run through the proposal that comes to the company for CSR activity. And that committee is titled as Corporate Social Responsibility Committee. We call them affectionately CSR Committee. And the composition of that particular committee, whether there should be an independent director or not, if my company does not require an independent director, can I do away with that and have only 2 directors? That has to be understood. Then you can do the CSR activity by yourself directly, or you can do it through an implementing agency. Because a company may not have the wherewithal to do the CSR activity which they are having. For example, we have decided to build toilet facility for all women children in rural places, for the schools, for the colleges, like that. The company may be doing a business of manufacturing PVC pipe. They do not know how to construct it. So they do it through what you call as an implementing agency. But still the responsibility lies with the CFO of the company, whether the money has been properly utilized, and give a certificate to the effect. But you can do through an implementing agency. But today the law has made it stricter that implementing agency, you cannot select a person of your choice just like that. He should be a person, or either a Section 8 company, or it should be a trust, or it should be a society, and they should have the income tax, what they call as relaxation that has been provided for the charitable institutions category, and all those things are there. And you have to route it through that. There are 2 kinds of projects have been identified. There are projects which is one-time payment. For example, I would like to buy an X-ray machine and donate it to a hospital. It is a one-time payment. Get a quotation, see that the particular hospital deserves that, and try to make the payment. CSR contribution is over towards healthcare. Now there could be a situation, as I was saying, constructing the toilet facilities, 100 toilets you want to construct, which may not be possible within a year. So it may spill over a year, in which case we call them as an ongoing project. but it should not exceed more than 3 years. So it should be more than a year, but should be within 3 years. So when you are having the assigned amount for the CSR activity for a financial year based on the percentage, and if you are able to spend on the projects before the end of the financial year, fine, disclosure alone in the board's report will be there. If you are having, say, 100 crores as the assigned money, you are able to spend only 90 crores and 10 crores is still left on 31st March 2022 because it was an unspent amount, then that should be transferred to the funds notified in the schedule within a period of, if I'm right, some 6 months or so. The time limit has been given within 6 months from the end of the financial year. But still, you must give an explanation in the board's report why you are not able to spend the 10 crores before 31/3/22 or 23, as the case may be. Now it's a spillover thing. Then if it is a spillover thing, then you must open a separate account within 30 days and transfer the money that is meant for that particular project and spend it for that particular project from that particular account. And how long I can keep it in that account? There again, the law provided, I think, 3 years as a limit. And after that also, some money is left out, transferred to the fund that has been mentioned in the schedule that has been provided. In short, if you see the various provisions, the intent is you must spend for CSR every year based on a particular percentage of your profit. And that money, if you don't spend, transfer to another account, it can never